Hi, everybody. Welcome to Square Off.
Liz, a Burlington woman is fighting a mischief charge for giving water to pigs she says were sweltering in a truck on their way to slaughter. Look, I'm all for showing compassion for animals, but we can't have activists breaking the law.
Well, the fact that she's being charged is outrageous to me. What did she do? She gave water to some thirsty animals when the truck was stopped. Sorry if that bothers the pig's owner. Lots of people have trouble with the way animals are treated. Who knows? Maybe even the truck driver does. The answer is not to send this woman to jail. We're going to debate that later on Square Off.
Ontario has set new limits on the police practice of carding or street checks. That's when police officers stop someone on the street for no apparent reason, ask for identification, then file that information in a police database.
The practice has been the focus of human rights groups and activists who say it impedes people's constitutional rights. But police have often said it's an effective policing tool, and stopping it will impede their ability to catch bad guys.
Joining us now to discuss the limits is Jeff Manishen. He's a criminal lawyer who also has experience as a Crown attorney. Jeff, random police stops are going to be banned by the end of the year. So what changes can we expect? Is there going to be noticeable changes here?
There will be. Where we left off, and I think we may have talked about this a while ago, the practice had been for intelligence gathering purposes. To gather information, police had been the practice of stopping people at any time without any particular articulable cause to ask for name and address and other information and get the names of the people who were in the group if it was a group, without necessarily having to tell them, you don't have to give me the information and you don't even have to stay here because I am arbitrarily detaining you. So what happened in that situation? We've had a lot of hue and cry, a lot of concern that you could have had race-based stopping, and it led to the Provincial Ministry of Community Safety looking into it, coming up with draft regulations. That's what's they're at right now. They're posted on their website. And what it does, there are certain ways in which it limits police to be able to do the conduct which we had previously called carding. They need to have some reasonable basis to suspect the individual is involved in some kind of criminal activity, or that the activity involved might well be suspicious, to be able to stop the person to begin with. And then there are circumstances in which they have to let the person know that they don't have to stay, that they don't have to provide the information, that they have to complete a card that sets out the information, including the officer's name and badge number and matters of that sort, and they even have to let the person know of contact information to make a complaint. So, to complain to police services. So they're going to be greatly restricted in when they can and can't do the stopping. There are going to be circumstances in which they don't have to go through that rigmarole, but certainly carding, as we've seen it and known it, is going to be greatly reduced, assuming the regulations get passed.
All right, Jeff, the changes by the government are being hailed as historic. Is it as big a deal as they're making out? Will human rights groups be now very pleased with the changes?
Well, I expect that they will be pleased to a considerable extent. I mean, one way in which we could identify the significance is that it really codifies that police officer is not allowed to stop somebody based on the individual's race, is not allowed to stop somebody by the mere fact that they're in a high crime neighborhood. So I expect that the practices are certainly going to be greatly changed. But you know what I expect will happen too, Liz? If these regulations get passed, it's going to create some real challenges for police. And it may well be that police are going to greatly restrict the practice of even bothering going through this exercise because of all the circumstances in which they can and can't do it and don't have to give information.
Jeff, do you think it is, in fact, an effective policing tool? And I'm not saying a random stop, but I mean, if you're a police officer and you obviously have some intuition, a gut feeling, something about this, I'm suspicious. Is that enough to be able to say, I'm pulling this person over?
The language in that regard, Mark, could be characterized as just a mere hunch, and that likely is not going to be enough. On the other hand, a standard that could be used can relate to a reasonable suspicion that the person is involved in criminal activity. Now, remember that for the drinking and driving laws, if an officer reasonably suspects somebody's got alcohol in his or her system, they can make a demand for a roadside test. So reasonable suspicion is a standard we see in the law. The idea of it is, can you articulate what the basis was for your having the suspicion, not just gut instinct, something more objective than that.
Like what?
Well, I would say you'd probably have to deal with, for example, high instances of a particular activity, criminal activity, let's say in a parking lot area, a history of particular times of cars being entered at that night, individual being seen in the area with potentially suspicious bulge in his pocket, or being in an area that shouldn't really be consistent with maybe the individual simply walking away from a car. There's an example of being able to stop somebody because now you're investigating particular suspicious criminal activity. or if you heard of a car alarm going off and you're responding in that kind of circumstance, or a home entry on a home security system alarm going off, and you see somebody in the vicinity, nature of the behavior and activity might be something that looks very suspicious.
Okay.
Now you're investigating a particular crime.
All right, Jeff, while we've got you, we also wanted to ask you about a really interesting case out of Durham. A judge ruled that police using a teen's estranged father to get a confession for a beating death was a betrayal of trust. Can you explain what happened here?
Sure, and this one is an extension, Liz, of the case law that we had from the Supreme Court of Canada that I think we talked about in this program too, about the Mr. Big confessions, where the Supreme Court said that if the police were having people pose undercover as criminals and trying to get the guy involved in the criminal gang activity and basically push him into making admissions about some criminal act he'd done, it could be considered potentially to be an abuse of the court's process, a fundamentally unfair practice. And so even though the person was not specifically threatened into making a statement or beaten or otherwise, or conventional police confession circumstances, it would still be fundamentally unfair. In a case in Oshawa investigating the beating death of a 4-year-old child, they had under suspicion a teenager, a 15-year-old, and he wasn't really coming forward with much information. Well, the young man had a dad who was estranged. They literally enlisted the dad to try and extract from the young man statements. And they had the dad body packed, and they gave him scenarios to carry out. And he wound up pushing the young man and trying to say to him, look, I'm your dad, I've got your back, never mind that the lawyers told you not to say anything. I'm here to help you, I'm really interested in you, and I want to know what happened. Now, ultimately, the young man did not make much in the way of admissions, some limited answers that could have helped somewhat. A judge felt that is an abuse of the court's process, not unlike the Mr. Big. It's really unfair. Under the Criminal Justice Act, young people have the right to be able to get the advice of a parent before making a statement to the police. Here, they're using the parent to get the statement.
Right. Let's move on to another topic. We've got about a minute and a half here. The Quebec Court of Appeal has ordered 2 big tobacco companies to put nearly $1 billion in trust for members of the country's largest class action lawsuit. Back in June, the companies, as well as a third, were ordered to pay $15 billion in damages to more than 1 million Quebec smokers. Jeff, we've known for a long time the harms of tobacco. At what point does a person have to assume personal responsibility for their choices?
Well, of course, we've seen that issue being litigated in the United States as well as in Canada to say the individual chose. The difficulty is that they are addictive properties that were in tobacco, as we've known for years and years, in cigarettes, that tobacco companies did not disclose, and that led to findings of liability. So I think that issue, Mark, has been litigated. The interesting thing here is that the Supreme Court, or the Court of Appeal for Quebec, has said to the tobacco companies, you're going to have to pay big dough in a series of installments. You aren't going to sit there and get to keep your money pending an appeal to the Supreme Court of Canada. You're going to have to come up with some of that money. In fact, all of that money staged now. You won't have the benefit of the use of it till the appeal is heard.
Okay, Jeff, before we go, I want to ask you, based on what's happened in this Quebec situation, 1 million people are going to be receiving money, some of them just for getting addicted. What's to stop every Canadian from forming a class action suit now and saying, well, I would like to get some money too, thank you?
Well, I think that the difficulty would be to show that you had a potential impact on you as a result of what they did. And just being out there in society saying, I don't like smoking either, you wouldn't be able to show you suffered any kind of loss. A person who suffered an addiction, a person who suffered compromised health. Actually, now in our civil justice system, we'd say you could quantify that they suffered some loss.
Well, you could say that
they need
anybody who
compensation
smokes
for.
is addicted. I mean, that's certainly not a stretch of anybody's imagination.
That's right, and those who got addicted through smoking cigarettes might well look to claim some form of damage or damages in relation to the impact that addictions had on them.
Right.
They'd have to show that they're entitled, but that's the basis for the claim.
That's criminal defense attorney Jeff Manishen. Always a pleasure, sir. Thanks for joining us once again.
My pleasure, too. Thanks, Mark. Thanks, Liz.
Thanks. When we come back, the war in Afghanistan remains fresh in most of our minds.
And an upcoming documentary highlights the realities of that war. We'll talk to its director next on Square Off.